All right, we will call the Ways and Means Committee meeting to order. I'm going to ask Chairman Knight to present HB 364.
Thank you, Mr. Chairman. If members will remember, about 3 years ago, we passed a bill, House Bill 399, and I'm sure you may not remember the number, but you'll remember the use of fruct bill. Yeah, that's right. It's back. And what House Bill 364 does is it makes it extremely clear that when dealing with this issue, especially the possessory interest, that we're not going to do this anymore. And if you'll look through the bill, the first section is basically giving the commissioner the ability to examine the itemized properties appearing on the digest. And if the commissioner finds that there's been properties that are illegally appearing on the digest and not subject to taxation under Title 48, that she can strike it and return it back to the commissioner, to the county. It also provides for appeal process in there. It also, if you look in starting line 25, if the property has been found by the commissioner not subject to taxation in this chapter, and it again in the future appears and is not taxable, then the commissioner shall notify the Department of Community Affairs, and above such notice, the qualified local government status of such county shall be revoked for a period of 3 years following the receipt of such notice from the Department of Community Affairs. There is a provision, I think, that's in here that will allow the county to rectify that within 6 months, okay, or before the final proceedings. So it will give the county time to rectify any issue here. And then if you look in 40, property again goes back to if this property has been found by the commission not subject to taxation within the last 5 years, and the owner, and it comes again, then the owner of the property shall be able to petition directly to the Georgia Tax Tribunal. In other words, we're going to skip all of the appeals and the local Superior Court. We're going straight to the Tax Tribunal so that this will not happen again. There are provisions in here for also for interest and legal fees. But we've worked very hard over the last couple of years to make sure that we were doing this right, that we were telling people exactly what was taxable under Georgia law, and we still have taxpayers that are getting taxed on real property that does not belong to them. But with that, Mr. Chairman, I hope that it explains the bill. I'll be happy to take any questions.
Are there any questions? If not, what's the pleasure of the committee? There's a motion and a second to pass. Any discussion? All in favor say aye.
Aye.
Any opposed? Passes on to rules. Chairman Stevens, House Bill 471.
Thank you, Mr. Chairman. House Bill 471 was an effort to bring these small equipment rentals in line with the large equipment rental without coming in with a tax exemption as the large ones have. What this does essentially is allows for a separate line item to charge their local ad valorem property taxes and pass that on to the consumer. And this will has a 4-year sunset essentially, so that we have to come back and revisit it once the numbers are there, so we can adjust, if you will, that number of 1.5% collected on property tax. That may be adjusted after that period of time once we get a track record. That essentially is the bill.
That's correct.
Are there questions?
For 34, yes.
Any questions? All right. There's a motion and a second. Do pass. Discussion. All in favor say aye.
Aye.
Any opposed? Passes on to rules. Chairman Knight, on behalf of Representative Ballinger, if you would present 793.
Thank you, Mr. Chairman. I think the committee has certainly seen this before. This is a bill that simply provides for an exemption for fraternal benefit organizations that are 125 years or older.
Are there questions?
Move to pass.
All right, there's a motion to pass. Is there a second?
Second.
Is there any discussion? All in favor say aye.
Aye.
Any opposed? As one no and the majority carries, it passes on to rules. Representative Flood, tell us about HB 828.
Mr. Chairman, House Bill 828 provides for an employer to get a $2,500 tax credit for every parolee that they hire. There are certain provisions for that credit to be applicable, including having that employee work for 40 weeks during a year and for at least 30 hours per week. I want to thank Representative Peake and Representative Knight for helping me to bring this bill to a point where we can move on it. I believe we've got some additional provisions that provide some performance metrics to ensure that we can assess the level of success of this program, and it's for 3 years.
Are there questions? What's the pleasure of the committee?
Move to pass.
Second.
All right, there's a motion and a second. Do pass. Any discussion? All in favor say aye.
Aye.
Any opposed? Passes on the rules. The chairman of the ad hoc committee appointed by the chairman of this committee has now arrived. We will hear him tell us about HB 960. Representative Kelly.
Thank you, Mr. Chairman. I appreciate you being understanding of me running a few minutes late. I have no good excuse for it, so I won't try to make one. Working off LC number 34489-6 this is a substitute to House Bill 960, which is the bill that came out of our special ad hoc subcommittee.
That's not it. 4901. 4901, you're right.
I don't have that one. Hold on a minute. Oh, that's the, okay. Sorry about the 4901 ERS. Mr. Chairman, again, this is a piece of legislation that's came about after we've heard of several situations where we've had large refunds being requested through our Department of Revenue, and they've had a negative impact on our local municipalities. So I'll just kind of walk through what this bill does. I know we've taken testimony and people understand the problem we're trying to solve here. So in Section 1, lines 34 through 36, we're just trying to make clear that the Department of Revenue can share information with the House Committee on Ways and Means and the Senate Finance Committee regarding the Department's administration of e-tax. We all recognize the frustration we had over the summer when we were trying to get certain answers, and the Department of Revenue didn't feel, and the Attorney General's office didn't feel like they could disclose any information of how they administer it to us. Lines 37 and 38, we make clear that there's a provision later in the bill for local governments to get a notification when a refund over 10% is requested based on the average of their previous 3 years' sales and use tax receipts. And so we're saying that when they get that notification, it won't violate the confidentiality. Next, in Section 2, this is where we changed the interest rate. We know that this was a big issue for many here, and the interest rate was 12%. Hadn't been adjusted since the early 80s, and so we felt it was time to bring that closer in. So we got a prime plus 3 divided by 12 will essentially be the new monthly interest rate. Recognize some concerns that we heard from the business community. We have now taken out the portion that interest will only begin to accrue once a refund is requested, and we're going to leave that where interest starts to accrue just as it is now when they first file, when they make their payment. Walking on through the bill, 61 says that if you file you pay your taxes electronically, then we're going to ask you to do your refund request electronically. Next, we got a definition section. There's a couple areas that we needed to address here. First, we needed to talk about who a political subdivision designee is, because they're the ones who are going to get the notification of the refund claim of local significance. So the next definition, and we see there that this is a 10% when a claim or for refund or overpayment for an amount equal to or greater than 10% of the total yearly average of the aggregate sales and use tax to any single political subdivision based on the 3 most recent calendar years. That's when they get the notification. We talk about the notification next. They'll get that within 30 business days. The local governments will. That notification will include the date of claim and the amount of claim. Again, something we are doing for the business community. They say, well, how will we know if it's a claim of local significance? So we put in a portion that they shall furnish the taxpayer with that notification as well. The next section, starting on line 88, is the confidentiality requirement. For our local governments, they will be held to the same standards as our Department of Revenue is on that specific notification they receive. Next, there's an issue for when there may be a SPLOST collected. The fact that the counties are the ones who are essentially get it, and then they distribute out to the cities. So what we allow for the SPLOST notification is that the county can then tell the affected cities, share that notification with them. So that's there to 98 through 106. Next, listen to our local government. Something that they had concerns about is the fact that they pay a 1% administration fee to the Department of Revenue, and sometimes there's just not a confidence sometimes in their work and in their minds, and so they have asked for a provision to be able to audit the department in certain ways. And so for those large claims, those claims of local significance, we put in a provision for them to be able to request an audit of the procedures by the Department of Audits and Accounts. On line 13, this is something where we've tried to look and seek, get all sides to the table and try to get them to resolve these issues in a timely manner. For any claim of refund of local significance, just these large refunds that are pending with the department for over 2 years, those are going to go to the tax tribunal for a show cause hearing, and I'll talk a little more about that as we get later in the bill. Again, in Section 3, this is just where we're changing the same interest rate to put it in line. I call it the what's good for the goose, good for the gander section. So this is when interest is due to the state or to our local governments. We're changing to that same prime plus 3 divided by 12 interest rate. Section 4 is something we've done in the property tax arena. We're recognizing, we're adjusting the penalty assessment here that went from a penalty of 10% after 90 days. So now there's a penalty of 5% after 90 days, and then 5% will be assessed every 180 days after that, and it's capped at 20% for property taxes. Finally, in Section 5, we're going to talk about the tax tribunal and the show cause hearing. And what we have here is once you get to the tax tribunal judge will make a show cause hearing to determine who is the one that's primarily at fault for the delay. If it was the department that's primarily at fault, the department will pay all the interest due to the taxpayer, and they'll also indemnify the local governments. If the tax tribunal determines that the taxpayer was the reason why the delay occurred, then the tribunal then the taxpayer will forfeit their right to interest, and then the third scenario is if the tribunal determines the delay is justified, then then there will be no one assessed, and it'll just be remanded back, and that'll be also the case in 1 and 2. In all these situations, we recognize that the department have to be remanded back to the department for a final determination of revenue. Finally, this is something that, again, we're trying to listen to the concerns of the business community on line 192. Any orders of this tribunal are to be excluded from the public disclosure, trying to recognize that keeping confidentiality is something we're certainly concerned about. Mr. Chairman, that's the bill, and I'll be glad to answer any questions.
Are there questions? All right, who's 26? Chairman Knight.
Thank you, Mr. Chairman. Chairman Kelly, and I'm sorry, I was trying to follow along as you were doing the bill, but could you go back and I heard something about the 1% or the collection, the local, and the audit part. Could you tell me again? Let's go back to that section of the bill and maybe go back over that again.
Yes, sir, Mr. Chairman. And the section I was referencing is line 107. And what we've done is we've put in a provision for, on these large refund claims, for local governments to be able to request for the Department of Audits to audit the Department of Revenue to make sure that they follow the proper procedures and they use the appropriate methodology to reach the final determination on the refund. And we're doing that just because there is frustration in our local governments that they don't have any way to fact check the work or look at the work done by the department. And this is trying where we've tried to strike a middle balance of them being able to actually review the department's work themselves. And we certainly have concerns. I have concerns about that. So we wanted to be able to give them something to where there was an extra audit where we could put another set of eyes on this, and that's how we came to the Department of Audits to do that. And I referenced the 1% because that's usually the complaint I hear from the local governments, that they pay the 1% administration fee to the department for collecting these, and they don't feel like they have any way to fact check the work that they're doing behind it.
So let me make sure, if you will, understand it. The Department of Audits will interact with the Department of Revenue. That's it.
That's it. Yes, sir, Mr. Chairman.
Representative Williamson.
Thank you, Mr. Chairman. Representative Kelly, and I don't know why I didn't catch this earlier, just begs the question, line 113, do I understand that it takes 2 years to get it to the Georgia Tax Tribunal? Can the taxpayer not get it there more quickly if they won't?
They can, Representative Williamson. But what we're doing here is that in the case where some of these refunds have drug out for extended periods of time, and we don't know who's at fault for those. Some have drug out 5-6 years, and we're trying to make sure that this puts pressure on both sides to get it resolved inside that two-year window. But we aren't affecting the previous the current ability that they had to get to the tax tribunal
That makes
quicker.
sense. Thank you.
Representative Carson.
Representative Kelly, first of all, I want to thank you. This is just a comment. I want to thank you for, I know this has taken a lot of time and a lot of hard work, and it is commendable how much you put into this. My question is in regard to lines 71 to 75 in regard to the definition of a refund claim of local significance. Going all the way down to line 76, average of the 3 most recent calendar years. Is this, I apologize because I'm just now seeing the sub, is this language, what would be the case if someone's been remitting tax to the Department of Revenue for, say, the past 18 months, and all of a sudden there is a significant event? Would this? So
we're talking about the average of 3 most recent calendar years for the local government. So,
right.
Say City A, normally gets $100,000 worth of sales and use collections over say that's their 3-year average, and then XYZ Corp asks for a refund of $15,000. That's when they would be notified of it. So it's more, the 3-year average is more, you're looking at the local government, not at the entity.
I got it. Okay. Thank you for clarifying.
Thank you.
14. Who's 14? Chairman
I
Houston?
think that's me. Okay, I'm sorry, I was reading this over. In regard to Representative Knight's about the counties having the Department of Audits to audit the Revenue Department, do you have to have any, I mean, can they just, everybody gets mad with the Department of Revenue and the IRS all the time and blames us for everything. Do they have to have a real legitimate thing, or just say, well, I know it was the IRS, I know it was the Department of Revenue? What guideline, can just any county do that?
Well, thank you for the question. But we're only talking about on a refund claim of local significance has been awarded. So it would have to be when a refund of over.
Where's that line?
That's on line 111 and 112.
111 and 112. Okay, so it has to be
And 108 and 109 as well.
Okay, because it has to be okay, reclaim it. I just wanted to make sure they just couldn't know everything.
I share your concern with
Yeah.
that too, and that's why we wanted to make sure it's these large refund claims that we're addressing here.
All right, and who pays for the audit?
That will be included. I think that should be just a service that the local governments are able to use for giving up the 1% administration fee that they do. So that would just be included. That would be a new service that they get.
1% administration fee doesn't sound like much for what they do.
Well, we feel like that if you're given the 1% administration fee, that they should at least have some way to fact check to work if they ask for it on these large claims.
But don't you think they ought to have a reason to doubt it? I mean, just not let every little large claim go back over it, have the auditors go over it.
Well,
We've got to trust these people somewhat.
I certainly understand, but they have no reason, they have no way to know that they shouldn't doubt it. I mean, because they have no ability to look over anything. They're just told a large number and a refund has been requested and has been determined that one's owed. So they have no way to know whether they should doubt it or not. So this is trying just to address some of their uncertainty that hangs over them all the time.
Okay, thank you.
Thank you.
Representative Rutledge.
Thank you, Mr. Chairman. I guess along the same lines, the local significance, you're saying that local governments, if they feel it's of significance, they can, so explain that.
No, so we define, thank you for the question, Representative Rutledge. Back in, on line 71, starting on line 71, we define what a refund claim of local significance is. And it's when a refund amount equal to or greater than 10%.
Gotcha. Okay.
Of the 3-year average. Thank you.
Are there any other questions? Chairman Rice.
I guess the question I would have is on the other side of the ledger in terms of the Revenue Department and the payment. I have no idea the dimension or the size of the potential payments that would be due in this situation. And given the time frame they have to operate in, is there enough time for them to budget for the repayment of these things within that time frame you've got?
Are you talking about for the department?
Yeah.
Or for the local government?
For the state government to pay these back. Yeah.
We're not changing anything on in that arena.
If I may.
I have no idea.
First of all, the department has worked with Representative Kelly throughout this process, and what we've been talking about and what was the impetus for this was a situation that arose in Floyd County and Rome and the other cities there, where a claim had been pending for quite some years. The local government knew nothing about it until the claim was finally adjudicated after audit and after negotiations, and then the local governments were notified that their share, the local sales tax share, was somewhere in the neighborhood of around $3.3 million plus accrued interest of $1.2 million. And so a large part of what we're doing here is, number one, changing the rate of interest to more of a market-based interest rate instead of the 12% that currently exists under Georgia law. But the other is that once somebody makes a claim for a refund that passes a certain threshold, is that the local government is notified that that is out there, so that they can start budgeting for that, so that when they do have to pay it back at some point in time later, it's not that they got surprised when it's been pending for 5 or 6 or 7 years.
Got it. Thank you.
Okay. Are there any other questions? If none, what's the pleasure of the committee? There's a motion and a second. Do pass. Any discussion? All in favor say aye.
Aye.
Any opposed? Good job.
Thank you, Mr. Chairman.
Now we have a little bit shorter bill. House Bill 982, Chairman Stevens.
Chairman, House Bill 982 is a very simple proposition. It's been squashed down into essentially one line. It has to do with problem we've got in Savannah, and I'm sure there's other places as well. It has to do with assessments of property, ad valorem tax assessments, fair market value, if you will. Whenever the assessor is using the income approach, has this added to it. If actual income and expense data are supplied by the property owner, shall be considered in determining the fair market value of the income producing property. There might be two properties adjacent to each other. I'll just use a mini storage. One is old, one is a relatively new that's considered to be 80% occupied, and they're being taxed in some cases the same because they are the same size and rental percentages. So this just says they can use their expense and income to prove their income on an income basis. There's no opposition to the bill, Mr. Chairman.
Other questions? Hearing none, what's the pleasure of the committee?
Second.
There's a motion and second. Do pass. Any discussion? All in favor say aye. Aye. Any opposed? Carries to rules. All right, we've got 2 bills left on the calendar. They are mine, so I'm going to ask Vice Chairman Peake if he will chair the meeting.
Thank you, Mr. Chairman. If you'll introduce HB 990 for us, please.
Thank you, Mr. Chairman. HB 990, if you will recall, under the law as it exists right now to protect taxpayers, there's a provision that if a taxpayer appeals and that appeal is granted, it has been understood that for a 3-year period after that, that the tax assessors cannot increase the valuation of that property, so that you cannot go through the process, which can be rather arduous and drawn out, and then immediately have to go back and have your property reassessed at the same value you just appealed it from. So you've got basically a protection for 3 years, and that's the law as it exists right now. There evidently is some confusion about the language as it exists in the law, and so there are opinions, legal opinions, which may have some validity to them that says merely by filing a notice of appeal, even if you win, even if you lose, or even if you drop the appeal after you have initially filed it, that it doesn't have to have any kind of resolution that's in favor of the taxpayer at all, that you could still lock in the value as it exists right now for a period of 3 years, which was not the intention of the legislature when this bill was initially adopted. But there does appear to be a possibility for somebody to abuse the system in a totally unintended way, and so this bill is intended to clarify that only if there is a reduction, whether by the assessors, by the Board of Equalization, by a hearing officer, or after court, or even by agreement, but some reduction, even if it's just $1, will lock in that value for the next 3 years. But if there is not a resolution through informal process or formal process that reduces the value to some extent, that there is no lock, and that's what the bill does.
Thank you, Mr. Chairman. Any questions from the members of the committee? Hearing none, what's the will of the committee?
Move to pass.
Have a move and a second. All those in favor say aye. Aye. Any opposed? Mr. Chairman, your bill passes, moves on to committee, to the Rules Committee. Shocking, I know that, but it's moving.
I'm gratified. Next is House Bill 1014, As you will recall, we have had on the books in this state to encourage people who have undeveloped land to keep such land in an undeveloped, perhaps pristine condition, is to permit people to make donations of conservation use easements to get a tax deduction for that. And then they've basically conveyed the development rights to the state. And that has been around for a while. There was a time when the program was fairly new that it was subject to abuse. Those abuses have been tightened up. But last year, when we were going through a lot of these exemption and credit provisions of the code, we put in a sunset on this bill and also put in a cap of $30 million to make sure that we wouldn't get surprised or blindsided by an influx of conservation use easements of $50 million or $75 million that might have an adverse impact on the state budget, and we wanted to limit our exposure in that regard, and so put in a $30 million cap. That sunset expires December of this year, and so all that this bill does is, number one, extend the sunset, and then the other thing that it does is puts in the reporting metrics that we've previously required in other tax credit or sales tax exemption bills.
Thank you, Mr. Chairman. Any questions from the committee? What would be the will of the committee? A move and a second. All those in favor say aye. Aye. Any opposed? Smart move. Mr. Chairman, your bill moves on to rules, and I'll turn it back over to you.
Thank you. There are no other bills on the calendar today. I will tell you that I am aware of one bill that is going to be heard in Sales Tax Subcommittee at 8:30 in the morning. Laura, is that correct?
Yes, sir.
Okay. And that will be a bill by Representative Bubber, or Chairman Bubber Epps. And then we have another bill, which is Chairman Rice's bill on TAVT. After I've had a chance to review it, if I don't find anything that causes me undue concern, we will move it to full committee. So we will have a short full committee meeting tomorrow to consider Chairman Rice's TAVT bill, and to consider Bubber Epps' bill if it moves out of Sales Tax Committee in the morning. And I promise you neither one of these will take long. And but other than that, I think that's going to wind up our business for the before crossover day. And so anyway, I thank everybody for being here today, and the meeting is adjourned.